Good evening, this is Rahul Reddy. We're live here every Tuesday from 5 to 6 at Central Time. We take live questions, so you can post the questions at this time. We're going to try to answer. Along with me is my business partner, Ryan. Ryan, what do you have to discuss? We're going to discuss about cricket.
We're going to speak, we have an hour, I think, or so we'll talk about the Pakistan-India game from Sunday. Are you ready to discuss, Mr. Reddy? No, just kidding. So we have 4 topics that we'll get across today. First, we'll talk a little bit about some common issues obtaining I-140s. And this is going to pertain mostly to the employee side of things rather than the employer. Some updates on AOS case statuses, ways that you can maybe read what is coming from USCIS's case status website. We'll talk a little bit about some accrediting bodies who have lost their authority to accredit schools and what issues that might bring in the future, whether your school might not be valid for your immigration purposes anymore. And then lastly, a few Dropbox issues. When can you schedule your consulate interview abroad?
So with regards to the I-140s, though, that is after we file the labor certification, we file an I-140. Now, when the experience letters are not there, Ryan, what evidence do we need to provide? Let's say I have 5 years experience in India and I can't get the experience letters. What do they do?
Okay, so if you can't get the experience letter, and by experience letter we mean like something on letterhead with the job title, the duties, and the dates. For me, that's what I call the perfect letter. Title, duties, and dates. If it's missing that, my first line of weaponry is, can you get a service certificate? Just something from the company saying your start date and end date. And if that's all you got, hey, that's at least something to work with. What we'll add on to that is maybe 1 or 2 affidavits from your colleagues at that job in India. It doesn't have to be, the CEO of the company. It shouldn't be the guy who's in the mailroom, but it should be someone who can reasonably attest to your experience. And then what we add on, what kind of bookends everything, is your Form 16. So that's the Indian equivalent of the W-2. Typically, if we can get those 3 things in lieu of, in place of that perfect experience letter, the affidavits, the Form 16s, then maybe just anything that we can get to pin you back to that company, like a service certificate, for me, that's good enough.
So a commonly asked question that pops up, Brian, is that, let's say, for example, the position only requires 2 years experience and I have 10 years experience. Do I need to provide 10 years experience letters, or any 2 years that will be sufficient for you?
Any 2 years would be sufficient. If the
So I don't need to provide all 10 years service certificates.
Save your time. You do not. Whatever the easiest letter for you to get is, as long as you can hit the years mark. So for Rahul's example, 2 years. Save your time, get the easiest letter you can find that shows 2 years, and then you'll be done.
And a lot of times the ability to pay issues comes in, Ryan, is that, let's say, for example, the prevailing wage is $120,000 and that person is only making $100,000. Will that be a problem in getting the I-140 approval?
It typically shouldn't, and I would say 99% of the time it shouldn't be a problem for sort of 2 reasons, independent reasons. One is that typically you can always cut down, Rahul was calling it the prevailing wage. You can prorate that or cut that down based on whatever your priority date might be. So Rahul said the wage is coming back at 120K. Mm-hmm. Let's say that your priority date falls July 1st, halfway through the year. Automatically we can take that 120K, cut it down to 60K. You're already being paid 100K, which is more than the required amount. So you get an approval there. The second point to make is that maybe there's the $20,000 difference. So long as the company can show that they have income or assets somewhere that covers that 20K, again, you'll get the approval there. So typically, their ability to pay issues, you should always pay attention to it, but almost always you can get past the mark if you need to.
Ryan has been associated with our firm. He's a partner in our law office. He's been with the firm from March of 2012. That's more than 10 years he's been associated with us. Ryan, typically how many I-140s do you do under your leadership, where you sign the documents and file?
We might be doing 500 to maybe 750 in a
That's
given
for
year.
you yourself.
For our team, maybe our office added 2 or 3 more attorneys.
But you yourself, how many do you do I-140s a year?
Around 500 if I had to put a ballpark.
That's approximately each working day, about 2.5 I-140s.
Yeah.
How many I-140 RFEs do you do every month, though, approximately?
In a month, we may get 10 from USCIS, so maybe a 20% clip on filings, and this never a guarantee, but we haven't seen a denial this year, maybe the last 2 or 3 years, knock on wood. And so if you get an RFE, it is nothing to worry about. It's just making sure you address it properly.
So let's say, for example, an I-140 has been denied for lack of experience letter. can they still refile I-140 again, get it approved after they get the proper experience letters or
Absolutely.
alternative requirement?
Yeah, you can after the denial, you can refile the I-140 even if the perm is expired. And so if you get a denial for whatever reason it might be, the very next day, really the same day, you can take your perm, even though if it might be expired, you take and you file it to USCIS. You might get the same RFE, but you can overcome it. That denial shouldn't impact you going forward in the future.
Rena, we normally get RFEs for the company where they ask all questions. Can you show the ability to pay for all employees, though? How does that actually work, though? How do you normally evidence, though? For example, you said in the example, let's say, for example, you filed the labor certification on January 1st of 2022 or 21 or whatever, the January 1st, and you have to show the 120,000 and you only have $100,000. You said rest of the 20,000, we will look into the profits of the company, though. What if there are 100 employees? Okay. How does that work out?
Instead of 100, maybe let's cut it down to 10, but we can use the same example. It's not the quickest at mental math. And so let's say we have 10, a company has 10 I-140s that they've sponsored. You're the 10th guy. The government might give an RFE what we call the ability to pay all, where they want to see that the company has the ability to pay the I-140 wages for each of those cases. So what do we do when we get that RFE? I put together a spreadsheet where we add up all 10 of those people's labor wages. We'll call that the liability. That's what we have to show the government that the company can pay. And then we take a same column and we add up all the W-2 wages. And so then we'll compare that number, what we've paid or what we project to pay these people versus our liability. I would say 9 times out of 10, the company is always paying more on aggregate than the liabilities. If it comes back less, perhaps, so say we aggregate everything up and it's 100,000 and they're paying 90K. As long as the company can then show that they have the tax returns, income, or the assets that overcomes any of that negative difference, the government won't have a problem with that at all. That 10th, that 11th, that 12th person should be getting their I-140 approvals.
There's a lot of presumption that the premium processing always gets an RFE. Do you believe in that?
I don't. We're just paying them $2,500 extra to do their job in 2 weeks versus what could be 2 years. And so I don't see the premium processing as a trigger. Generally, I think 1 in 5 cases is going to get an RFE, and that's just maybe the government meeting their own quotas, making sure people are staying busy. But no, I would not say that premium processing at all is any trigger.
Anything else before we move on to the next topic? Right?
No.
A lot of people are asking the question that when they go to AOS, they check their status online. It's saying that fingerprints applied. What does this mean? That's a normal question. The fingerprint applied used to be there before. Then later on, people may have been interviewed. People may have got an RFE. They responded to the RFE. It is saying fingerprints applied. That means the case is pending, guys. Don't panic. It's not going to cause anything. It's just that AOS case is pending. You're in good shape. You do not have much problems if it is like that at all. You don't have to panic. We do have a daily conference call where people come and ask the questions about it, saying that, oh, my case says fingerprints applied. It used to say before, now I've been interviewed, it says again. No, you are good. You don't have any problem. Now, Ryan, recently we had Stanford University, not Stanford. Stanford University has been closed. And it seems that there is an accredited agency out of 7 or 8 accredited agencies. One of the agencies, ACICS.
Yep.
And there are approximately about 85 universities or colleges that are accredited by the ACICS Institute that was authorized to accredit a university. So my question is that right now there is a rumor spreading around that the ACICS would lose the accreditation. That means the agency that accredited, that can give accreditation, loses the accreditation. Mm-hmm. That means that entire universities are going to lose accreditation. What's the truth in that?
So that's complete truth. Just to give a quick background, there's the Department of Education through the federal government, and they go out and they've picked 10 bodies that say, okay, you are worthy to accredit colleges and universities that they're worthy of our standards, so to speak. ACICS, the Accrediting Council for Independent Colleges and Schools, is one of these bodies. And so what happened is the Department of Education looked at them and said, we don't think you're good enough. This was back in 2010. Fast forward to 2022, now August, it's become official. They have lost their ability to accredit schools. So from today through the next 18 months, I think that puts us into February 2024, those schools are still good. So they're still provisionally accredited. So if you're getting the degree, if you're graduating from one of these non-accredited ACICS schools from now until early 2024, you're fine. But if you're attending one of these ACICS schools and they have not got a new accreditation, or if you're getting the degree after early 2024, you're going to find yourself in some very real immigration consequences. Boiling it down, essentially the government is going to require that your US degree be accredited if you want to use it for any H1B or any EB2, sometimes EB3 related education experience requirements.
And what should people do right now if they are from that particular university?
So forgive me for saying Google it, but you can Google Department of Education accreditation agencies and it will take you right to their website and you'll be able to put your school in. So whatever school you might be, whether it's the University of Texas or Stratford University in Northern California, you can plug in your school and it will tell you exactly when the school was accredited, who it's accredited by, when their accreditation needs to be renewed, and if their accreditation is bad, like this ACICS, it will tell you how long that school will be provisionally recognized.
A lot of people are asking questions with regards to the consular appointments. Because if you are, consular appointments are they're taking a long time. And if once you go to the consular website, after you complete all the necessary requirement, it may give an option to you to either have a Dropbox or have a personal interview. A lot of people are asking, I am eligible for Dropbox. If I pick for the interview, is that something bad? No, it's not bad. If you think so that you want to get it faster, if you think so that you want to get the interview done, you want to have an appointment faster and you want to go with the interview option, it's not illegal. As long as the online system is allowing to pick any of the both options, and it's your choice. You can book either of those options, you are in good shape. Absolutely not a problem though. Any other things before we go to questions, Ray?
No.
Questions are asked for people who have interfiled to EB2 and now the priority date is backlogged and they have an EAD approval and they have only filed 148 application. The question they normally are asking, and I see some questions there, is that is my EAD on EB2 or is my EAD on EB3? Because I got the 485J supplement, I did not get the 485J approval. Well, here is the answer to you. Your EAD is given to the adjustment of status. It is not given to EB3 or EB2. It can be considered either of those things depending on which is advantage. So you can use the EAD and later on you can say you're an EB2 or you can say you're an EB3. So you don't have to worry that it is only given to EB3 or EB2.
I lost my question there. So one question came up about, this is from Jay on YouTube. He said, my company filed my I-140 almost a year ago and they still haven't received the receipt notice. Or maybe he's not sure if they're providing them that information and ask, how can I find out about the receipt notice? 2 points to make. Unfortunately, point one, the company doesn't have to tell you about the I-140. It's probably going to be in their interest to do so, but from a legal perspective, they're not required to tell you anything about the I-140. If you're able to get the receipt number, or you're saying you're not going to be able to get that, one thing that they can do if they maybe haven't seen the receipt notice, check with the bank, look at the check that was sent with the I-140. Whenever the government takes the case, they'll stamp it on the back with the receipt notice. That's your frontline evidence that it's been received, but you're going to need to check in with their company to really see if they actually filed this I-140 for you.
Another way that you can find out the I-140 receipt notice, you can file a Freedom of Information with USCIS. It will take about 3 to 6 weeks and your employer won't even know that you filed for it. And you can do it online, it's free. Just Google it with FOIA USCIS and you can go to that website and fill that information. You will get your 485 receipt notice. If it's approved, you'll also get the approval notice too. And good thing is that you will also get your labor certification when you file this Freedom of Information.
That's a great point, Rahul.
Ashok is asking the questions, what chances of unused 60K green cards will be provided to Indian nationals? Ashok, one thing is that since they are telling the other country nationals, that is the rest of the world, is going to be oversubscribed, especially for EB2 section though. If it is oversubscribed though, we are not going to get approximately out of 60,000, I think so about 17,000 or so green cards will be allocated to the employment based 2 category. Out of that, Indians can only get 7.1%. I may be a little bit here, there on that 7.1%. So only 1,200 of that extra 17,000 will be given to the Indian nationals in EB2 section though. It's not that all 60,000 are going to come to Indian nationals, which previously we predicted. In 2021 we predicted, in 2022 fiscal year we predicted that all extra green cards will be given to Indian nationals. But what happened was that, Ashok, is that when the rest of the world demand goes up though, Indians will get restrictive green cards though. They are guaranteed for 7% though, but above the 7%, we need, the rest of the world has to be emptied. For example, last year, fiscal year, that is 2022, which ended on September 30th of 2022, starting from October 1st of 2021, we had 280,000 green cards. I expected anywhere between 140,000 to even 180,000 to be given to Indian nationals. But what happened was that the rest of the world demand went up. So since they consumed most of the green cards though, the leftover Indians out of the 280,000, we are supposed to get approximately maybe 20,000 green cards is guaranteed to Indians. But I expected 180,000 green cards to be given to Indians. But we ended up only getting 90,000 green cards because the rest of the world has used up the 180,000 green cards or 190,000 green cards were used up by the rest of the world. So coming this year though, we have 200,000 green cards. If the rest of the world are going to complete their quota though, that means that they have oversubscribed though. Indians will only get 7% of the 200,000, which is only 14,000 overall. And in EB2 category, we're going to get only 4,000. Now in EB3, we may get a little bit more because we don't know if the rest of the world is going to use up the entire quota that has been given. If they don't use up, we may get more than 4,000. But EB2, they're telling it's going to be only 4,000 given. 4,000 includes 2,800, which is already there. So we are not going to get all 60,000 green cards. Even though previously we may have predicted that, we did not, or we underestimated the rest of the world demand. So that's a bad news for us though. So the best thing, Ashok, is that right now is for us to lobby the administration to not count the family members though. There is a letter that we have provided at the bottom, link there. I want you guys to write the letter because the rest of the world will be given preference. There is nothing you and I can do about it. It's a law. The administration has to follow it. It's the parliament or Congress that passed it. The administration doesn't have an option. Oh, we're going to leave the rest of the world. We're going to give to Indians. They cannot do that thing. Unfortunately, they cannot do that thing. So what they can do right now, if they want to, is not count the family members. If they don't count the family members, guess where we will be? Instead of 200,000, well, that will be almost like 400,000 green cards for us for this year. Going forward, it will be approximately 300,000 green cards every year. So that's the only thing. The rest of the world is going to increase. We can see the rest of the world also, people filing more green cards in our office and elsewhere too. So we will be, the backlog will be very significant unless something is done.
Chintan asks on YouTube, my perm was filed January 2022. They're telling me it's still pending. How can I verify that it's still pending? Not even employers can verify that it's still pending. You're essentially taking the Department of Labor at their word. But what I will tell you is the January 22 processing or the filing date, you're within what I would consider the normal processing time. Just within the last 2 weeks, I would say I'm starting to see the perm approvals coming with the January 2022 priority days. And so you're probably towards the front of the queue. Don't take it as a promise, but you'll probably be seeing the approval in the next month or two. And then from there, you'll be able to file the I-140. So right now, you're in a normal spot.
Sarvanan has this question. A lot of news is coming with regards to the H1B stamping getting done within United States. That news is actually not right, though. The reason is that what we notice is that the reason what we notice is that there is a presidential committee on South Asians. This presidential committee passed a resolution to have the passport stamping get done within United States. This presidential committee does not have any tooth. It is not part of the congressional committee. It is not a part of the administration basis. It's just like, the president will have committees for a lot of different things. One of the things that they will have committees for is Diwali festival. Okay, let's have a committee for Diwali festival. So just because you have a committee for Diwali festival doesn't mean if they pass anything, it's going to become a resolution. It's administrative policy, though. That's definitely is not since it's a presidential committee which doesn't have on South Asians, and these are normally some South Asians appointed to it. It does not have any tooth to it. Was there a discussion done on the passport stamping? Yes, there was a discussion done on the passport stamping, and that discussion is there. But at this point of time, there is no official talk with regards to the passport stamping by the USCIS, by the Customs and Border Protection, or by the Department of State. This should be done by the Department of State, not by the USCIS and CBP. And of course, USCIS and CBP should be on board of it. At this point of time, there is no serious considerations. There is no serious considerations right now that are official that says that passport stamping can be done within United States immediately.
And then we have an ACICS related question from Kumar on YouTube. Got his degree from Stratford University. This is a school that was ACICS accredited. Just applied, he got a degree in 2009, just applied for their EB2 485. Asks, will there be any issues for the 485 because of the university closure? I would tell you no, that you're not going to have any issues. One, when you got the degree, the school was fine, ACICS was fine, no problems there. For you, all of those issues in the past, the only people I would tell to worry about these ACICS degrees are those that are going to be graduating in 2024 or later.
What about one issue that I have, Ryan, is that if they have obtained the H1B, though, in the master's quota from the Stratford University, there may be a technical issue there, Ryan, because it's a for-profit university. For-profit universities are not, cannot be counted in the master's quota. Only non-profit and accredited universities from the United States will be allowed to apply for the H1B. So if you got the H1B somewhere in 2011 or at that point of time, in the master's quota, though, you may always face an issue at a later time because you should not have got the H1B approval from the master's quota. Because Stratford is a for-profit university, it is not eligible. So that slight deficiency is there. Even though the accreditation is still valid, there may be some issues with regards to the H1B. So depending on your H1B, how it has been filed, you could face some problems on that thing. I have done PhD in statistics from India. Can I apply for my GC under STEM? Please suggest. There is no green card, guys, under the STEM alone. Just because you have a STEM, there is no green card, though. The only thing people have specialty, at least right now, is that if you obtain a STEM degree from United States, and if you have done the bachelor's degree or master's degree, typically you're allowed for 1 year of OPT. And if you have a STEM degree, if that degree, either bachelor's or master's, is a STEM degree from United States, you're allowed 2 years of OPT extension. We call that as a STEM extension. But you have a PhD in statistics from India, that automatically does not allow you to apply in a GC under STEM. There is no GC under STEM at this point of time. Now, however, Ranjit, there are some proposals for the people who have doctorate in STEM degrees, but at this point of time, there is no law that is passed. So you're not, just because you have a STEM degree, you're not eligible, but you may want to consider other ways of applying. EB1A category, that's one thing that you can think about it. It's called extraordinary ability. You can also consider thinking about EB1B category, outstanding researcher, because you have a PhD. You may want to consider any of those things.
And one thing to add on, Rahul, EB1 for Indians is probably always going to be preferred over EB2, but what you can do with your STEM PhD is file for what's called an EB2 NIW, a national interest waiver, where you don't need a perm, which means you don't need an employer sponsor, and essentially you can make the argument that whatever it is that you're proposing to do based on your education is somehow in the national interest. And the Biden administration has been very strong with wanting to recognize STEM fields and lends very favorable weight to those with STEM degrees such as yourself. So it might be worth something to consider, where if EB1 is out of the window or something you maybe don't qualify for, not going to hurt you to make an EB2 NIW case.
Ren, can you explain more? EB1, EB2, EB1A, EB1B has been there for a long period of time, and national interest waiver has been for a long period of time. There is no Congress change. What did the administration did change something on the STEM? Can you explain more why this administration is more proactive in promoting the STEM people?
So to answer that question directly, why is this administration so intent on bolstering STEM immigration? Well, they view it twofold. One, it's a great way to import foreign labor who are going to contribute to the American economy, to the American society, and are probably going to become American citizens whose children will keep benefiting this country. And then two, they view it as a national security interest, that the more people who we can get here who are STEM qualified individuals, we want those people to be the ones who are continuing to drive forward our economy. So that's why the administration is really giving favorable weight to the STEM programs. One, essentially it's a labor issue, very highly skilled labor. But what have they done to make STEM easier to leverage to the government? The president, Joe Biden, no president who comes into the office can change the rules. Congress has said these are the rules A, B, C, D. What the president can do is they can tell their officers who are reviewing the law, this is how I want you to understand things. These are how I want you to read certain words. And so when they're looking at the STEM degrees, they're saying if the person has a PhD, you should be rendering very favorable weight to them. If they're doing a proposed endeavor that's going to revolutionize auto manufacturing, that's another thing that's adding in. So they're wanting to look at these things and say, hey, what do you have in your background? Is it STEM related? If so, we're going to give you very favorable weight to that. And we're already seeing some green card successes on those cases.
Who is eligible for the concurrent filing of I-140 and I-485J? The people whose priority date is current, they can file the I-140 and I-485J and I-485 at the same time. So it's not that you're going to file just I-485J. You would like to file I-140 and I-485, then you need to, that's the main thing though. You can't file I-140 and I-485J alone, but you can file I-140 and I-485 now. You cannot file I-140 and I-485 together unless your priority date is current. So your priority date is only current. Your priority date is current based on the labor certification. You already know when the priority date is current. So only if the priority date is current you can. So for Indian nationals though, EB1 at this point of time is current. EB2 is not current, EB3 is not current, unless you're putting the date from the previous labor certification or from the previous I-140 to this one. You cannot file I-140 and 485 together.
I saw one question earlier, so whose name I apologize for not giving, but was asking, I filed my AP, I was outside the country when my AP was approved, now I'm back in, I've got the approval in my hand. Can I use that AP to travel now? Or would you consider that AP, my AP was approved while I was outside the country, now I'm back in. Would you tell me to travel on that?
I'm a little bit cautious on it, though. If the advance parole has been approved, first of all, is it an initial filing of advance parole or is it an extension of advance parole? With the extension of advance parole, I never seen any problem at all. With the initial filing of the advance parole, though, can you travel on it? I haven't seen any problem with it, Ren, but you never know when it's going to hit hard. You never know when it's going to hit hard. Question with regards to OPT. Do I need to be in? Do I need to get paid while I'm an OPT and STEM OPT? The answer is no. A training is okay. You don't need to be actually getting paid for the OPT period. Now, if it is a STEM extension, though, you have to be paid. But when it comes to the OPT alone, you do not have to get paid.
And then we have one question from Muhammad on YouTube. Asks, we filed our 485 and cross chargeability in October 2019. The case, the 485, is still pending. What steps can I take? I'm going to assume, and forgive me for assuming, that you're Indian and your spouse is a non-backlogged country. If that assumption is correct, then your priority date is still current because your spouse, that's your country of chargeability. What you can do is you can place a service request with USCIS. If that's not successful, you can elevate it to what's called an ombudsman's request, or maybe contact your local representatives or the senator for immigration assistance. Maybe they can just see what's going on with the file. Whereas if your spouse, even though you did the cross-chargeability, if they are in a backlogged country or whatever country they might be has seen a retrogression, well, you're waiting in the queue, as most Indians are, waiting for that cross-chargeability date to come current. But just to circle back, if you are current, if everyone's dates are current, or if you think that they're current, it's not going to hurt you. The government's not going to look at you negatively by putting in a service request. It might just give them the nudge to clear the dust off the case and bring it up for final approval.
Never forget that you can sue the USCIS.
That's a great point.
I want you to watch the video, which we're going to post it tomorrow on YouTube, that addresses especially on litigation, because if the 485 has been pending for more than 1 year, and if your final action date is current, you can sue the USCIS. That's the best option that you have, is to sue the USCIS.
I saw one question just a moment ago on 485 processing time. So priority date was 2010, so we're no worries about that. Case was filed to the National Benefits Center. What should I expect for a processing time? That's the billion-dollar question. To be frank, it could be 2 months. It could be 2 years. Why things take so long once it gets to the office, we don't know. The government's not very clear on that. So you're in the queue. You've got the 485 pending. That's a very concrete, beneficial step. You'll get the AP and the EAD shortly enough. And so you're in a good spot. But right now, I wouldn't want to give you any false hopes on what your expectations might be. Generally, I would say 18 months is a good ballpark.
Stats B from YouTube asks this question. I have a valid H1B until 2025, but I got my EAD combo card on October 2020. In October 2025, travel in 2023 am I automatically on EAD? No, you're still on H1B. The USCIS is very clear that if you travel on advanced parole, if you have a H1B or H4 still valid, you are good. We do not see any problem at all in there. We do not see any problem there. Rain, there are some people who are getting these vague calls from the Department of Homeland Security saying that your Social Security has been compromised. You need to move.
I made $390K last night alone with these calls, Raul.
390K.
Yeah, these are bad scam calls that we're hearing about.
And this is the scam what we have uncovered. Actually, there is a second case when I discovered is $1.2 million. And we just want everybody to aware that if anybody is calling, the government officials are calling, and they are asking you the money, they are fraudulent. Period, guys. Period. No matter how they threaten. We have had a lot of problem. They come on the phone, they say that your Social Security has been compromised, you have to move, and they have faxed 18 pages of all the fraud that this gentleman has done on his name and his Social Security. He has to go to the UPS to get the documents. And he has went 7 times. They have provided all the different fraud that is conducted on this guy's name. And this guy got so scared and he transferred $370K. And Rain, I asked him, why would you transfer $370K to Hong Kong? They said that since your name is since your Social Security is sacrificed, and because they're going to close your bank account, since they're closing your bank account, they need to move the money internationally and transfer the entire $370,000 again. And they said to get the money back, he has to pay the $18,000, right? And he sent the $18,000, completely gone. All money is gone for him. And now they don't respond to him at all. And that's what it happened. That's what it happened. And when he called the police, Ryan, this is what the police were telling. Oops, we got another call 2 weeks ago, and they duped him for $1.2 million. These are the scam callers. We want you guys to be well aware of it. Please, I can't put that guy on the YouTube because he's so insulted, degraded, he doesn't want to come up. Otherwise, I would have put him here just like I put Ryan on there. He's just very annoyed, and he can't express how dumb he has to pay the money. And he doesn't want to be on YouTube because when we tell these stories, you guys don't believe it. And this guy wanted me to tell this story today, and he wanted me to tell the story about the 1.2 million. Of course, they don't want to come because they will look so dumb when they come and explain it. How? So if anybody is calling you and asking the money, guys, no. And one thing that, the first thing that you need to contact is a lawyer. And when a government official or any official is calling you and they say that I want to speak with my lawyer, they say no. No, you say you have to speak with a lawyer. They can't say no, guys. You have to speak with a lawyer. So definitely that's a great indication that, and it is confidential. Lawyers are confidential. There is confidentiality is built into the system. If you call a lawyer and you tell the lawyer, let's say for example, you call Ryan and you tell Ryan, I murdered somebody. Ryan cannot tell that to court. Ryan cannot go to the police station and say, my client murdered with the knife, go and catch him. He cannot tell that thing. He can either shut his mouth, he can represent you, he can choose not to represent you. And if he does not have any right to go to police or to inform anybody saying that you murdered with a knife somebody else. And if he does that, the judge will put a gag order on Ryan.
I'll lose my law license. Rahul will fire me.
I will fire him. He will lose the law license. He will never be able to practice law in his lifetime. And this rule is not for just Ryan. It's for me. It's for every lawyer that's there. It's a confidentiality. You may not have confidentiality with your friend. You may not have confidentiality with the doctor. There are some limitations where the doctor can release. When it comes to us, you come and tell, you murdered somebody. I stabbed the guy 4 times and you come and tell me. I can't tell that to anybody. I can't. At the most I can say I can't represent you or I can represent you. That's my option to pick. That's Ryan's option that's any lawyer's option to pick. But what they cannot do is they cannot go around at the back of you and tell that you murdered somebody. If they do, as Ryan said, they will get fired. The court will put a gag order. They will lose the law license and they will never be able to practice law. That is the law in the United States. And fortunately, that's a law in India too. So please, if you have any insulting thing where you feel that thing, you don't want to discuss with something, lawyer is a perfect guy to call and say, hey, this is what's going on, what do I do? At the most, lawyer can tell you, you are the worst person in the world, I'm not going to represent. That's all he can do. He cannot do any more harm than that. So please be careful when these people are calling. Very lot of times people feel, oh, they're threatening me, I'm going to go to jail. Calm down, step back, speak with a lawyer. You'll be in a better shape, and don't fall into these victims. These people are just calling and whining. And there's nothing. The money is gone to Hong Kong. They called the Hong Kong police. And then I don't know where the Hong Kong from there it went to. 1.2 million, 390,000 also. And that's a lot of money, guys. And please be careful with these scammers.
Exactly. And then Chris asks, may I port my 485 from, I'll cut it down. Can I port my EB3 from employer A to employer B who's doing an EB2 I-140? So essentially, can you port your priority date from an EB3 case to an EB2 case? The answer to that is absolutely. You can take an EB3 priority date, move it into an EB1 case. You can use an EB1 priority date and move it to an EB3 case. Anywhere in between. As long as it's EBs 1, 2, or 3, you can take the priority dates and port them between any of those cases that you choose.
Question from Amit Indores is asking, success of interest need to file a H1B amendment. It depends on, though. There are certain circumstances where it depends on whether or not. We need to speak with the HR to figure it out if ever we need to file an amendment. Most of the cases, though, successor of interest does not require an amendment.
ES 350 asks, may I re-enter with advanced parole even if the I-94 is expired? I'm going to assume that you mean the I-94 based on your non-immigrant visa, so your H1B or whatever the case might be. As long as your advanced parole card is valid, the day that you're showing up to the border, they're going to allow you in on the advanced parole.
I think so. There's another question that comes up, Ryan, is that let's say, for example, if the advance parole is valid for 2 years, so let's say you got an advance parole in December of 2021 and it's valid until December of 2023. And when you go to India and come back, though, they typically give an I-94 only that expires in 1 year. So let's say you entered into the United States in February of 2022. Your I-94 then expires in February of 2023. Now, even though your I-94 on the advance parole online expires in February of 2023, if the advance parole expires in December of 2023, you only look into the advance parole approval. Don't look into the I-94. As Reddy has pointed out, that look into the advance parole. If it expires in December of 2023, you can travel until December of 2023. Even if the online advance parole says that your limit is only 1 year, you can ignore it.
Ranjit asks a follow-up question from earlier regarding STEM green cards. States that the company filed the green card under EB2 just recently. Should I wait until that I-140 is approved and then ask the attorney for the STEM exception? I would tell you that's a step that's just unnecessary. One, you've got an I-140 taken care of, and I'm assuming it's going to be the same company who would do the STEM exception. I-140, as you've called it, that's already done the EB2 I-140. There's no difference between an EB2 regular and an EB2 STEM, EB2 NIW. It's just an EB2 case. So you're not gaining anything extra by taking a further step and doing this what you call STEM exception. I'll call that an EB2 NIW I-140.
Sumit Dignani has this, he has a dream that there will be a day people will stop watching these stupid videos as a result of the stupid immigration system. I'm with you. Sunny, I am with you. It is really stupid immigration. The way they discriminate between Indian nationals and non-Indian nationals, it is stupid. And the complexities that they have is stupid. Canadian system is much better. Do they have all these kind of complex things in Canada? No. The Congress need to act, Sunny, and we need to advocate the Congress to act. That's the only way we can do that thing. Yes, it should not be this complicated. I completely agree with you. If they have to look into what talent that you have, we should not look into which country you come. That is really stupid. I completely am with you. I hope all the people will get the green card as soon as possible and stop watching these kind of videos. Definitely, the longer the duration that you're watching these videos, it's not a good indication. We expected all these backlogs to be gone, at least to a significant amount. That didn't happen. The next step for us is to remove the per country cap that may come in, especially after the elections are over. We'll get again one more chance to remove the per country limit. That's one thing that I would like to advocate. The other thing probably would be is to have the family members not counted. The third thing that I advocate to stop watching this thing is, what if we file, once I-140 is approved, if we are allowed to file the 485 and EAD, that will become so easier for us, so simpler, because we don't have to do all complicated H1B, H4, every time we go to stamping. All those things can be avoided. So let's try to achieve that, guys.
Raul, you might be able to add some insight on this. I know you talk with Stephen, our litigation attorney, a lot. Chris asked, what happened to the litigation against the Department of State, asking for the client letters, essentially giving these 221G denials. Now, I know in the last few weeks, maybe the last few months, he started this litigation on this issue. What
Yes.
are you seeing success-wise coming from that?
It's turning out to be very good based on Steven. In fact, the video will be posted by end of this week. We already recorded that on the 221Gs. The people who litigated on that, part of our immigration team, is Jonathan Boston and Stephen Brown. Were part of the litigation where the end client letters litigation. We have been very successful with USCIS. Why do we need the end client letter? It's not there in the regulation. Now, what Stephen says is that when we go to the consulate, though, why are they re-adjudicating the entire H1B application, which is already approved? Why are they asking the end client when there is no requirement here in the regulations to ask for the end client? So he's been doing the litigation. That's been going very good. If anybody are interested, you're stuck in the 221G outside in the consulate, please contact Stephen Brown in our office or watch our video. We're going to post it by end of this. It's already recorded. It's going to the editing process by end of this week. We're going to provide that one.
Let's see. Gokul asks, is the 180-day portability for 485 valid even if there is a loss of employment after the 180 days? Yes, absolutely. So my view is essentially once you've got the 485 filed, let's assume the I-140 that supports that 485 is already approved. So once you've got the 485 approved, by and large, you're good to go.
For I-140 approved, you mean to say?
Yes, the I-140 approved and your 485 is pending. I would wait until day 181 to put forward a portability request, take that job from company A to company B. But if you file your GC, your I-140 is already approved and you file your GC on day 1 and on day 2 you get fired, that's not going to result in the denial of your 485. One of two things is going to happen. You're either going to get an RFE, the government's going to ask you to give a 485J from company B under this portability provision, or you're going to get an interview notice, at which time you walk in and you give them a 485J from whatever company you want for a same or similar job occupation, and that's the end of the road. So Gokul, if your 485 is pending, you're in a good spot. Even if maybe you were laid off, your green card journey is not at an end, you might have to put forward a new 485J in the future, but the health of your 485 is valid. So no worries there.
So it's only 180 days from the time the 485 has been filed. If he loses a job, then he finds another employer.
Exactly.
Okay. Sounds good. It doesn't have to be that I-140 has to be approved for more than 180 days, as Ren has pointed out. It's only the I-485 has been filed and 180 days has been passed.
Assuming the 485 is approved, yeah.
Assuming I-140 is approved.
Yeah, I'm sorry. I'm getting a lot of numbers thrown together. Sorry, guys.
Can you explain about the I-140 approval in general, though? When you can put the date, let's say, for example, I have an I-140 approval for a company and my I-140 is approved only for 100 days. Can I move to a new company and put the date?
Absolutely. My view is that so let's say company A did your first I-140. The very moment the government approves that I-140, you are vested with that priority date. And so on day 1, you can quit company A and go to company B, who's going to file your Perm and your second I-140 for you. That very moment you have the priority date, no problem.
What if the company withdraws I-140 within 180 days?
The issue you'll have is not I-140 related or GC related. It's going to be H1B related. So if you have no other I-140s and company A files your I-140, it gets approved on day 1, on day 2 you leave, on day 3 they withdraw, you cannot use that I-140 approval for H1B extensions or for H4 EAD. And what you need the I-140 to be approved for 180 days, and after that, even if the company writes the nastiest letter about you to USCIS, the government will simply respond, hey, it's too late, it's after day 180, we have to allow this guy to use your company's I-140 for H1B extensions with company B, C, D, whatever the case may be. So if you're thinking about leaving and it's before day 180 of approval on the I-140, the priority date's yours. Whether or not you can take the I-140 with you to the next company to do your H1B extensions is a question of, has the I-140 been approved for 180 days?
So what you're telling, Stephen, is that I can put the date even if it's withdrawn before 180 days.
Absolutely.
But if it's been withdrawn before 180 days, I can't extend the H1B beyond 6 years. And if it's been withdrawn before 180 days, I can't use it to get the H4 EAD.
Correct.
But if it's been withdrawn after 180 days, I can still get the H1B extended beyond 6 years.
Absolutely.
I can get the H4 EAD extended
Until your priority date's current, and you can file your green card.
And what if I move to company B? I'm not working for company A anymore. I move to company B. Can I extend H1B beyond 6 years with company B using the company A's I-140?
Absolutely. I would say that's more commonly done than getting the H1B extension with just company A.
Can I use company A's I-140, which is not withdrawn within 180 days, to get my wife H4 EAD with company B?
Absolutely.
Can I use company A's I-140 to move from company B to company C?
To do like an H1B extension?
Yes.
Yeah, absolutely. And you'll keep the priority date, you'll be able to do the extensions and all that. The government won't care at all that you're using company A's I-140. They're not going to ask any questions about it. All they want to see is the approval. Boom, there's your extension.
There is some rumor that says that I-140 can be withdrawn after 180 days, or it cannot be withdrawn. What is the truth in it?
So separate your mind between the employer's mind and the employee's mind. From the employer's mind, we always have to show that we have the ability to pay, we talked about this at the beginning, your wage. And so if I haven't withdrawn your I-140, I still have a liability that I have to show that I have the ability to pay your I-140. And so if you've left my company to take care of that liability for me as the employer, I withdraw your I-140. I never have to account for it again. That's the employer side. On the employee's side, once the I-140 gets to 180 days, even if I as the company send the letter to say withdraw, they're going to send me back a letter that says, pursuant to XYZ statute, the I-140 is going to remain approved because it's been approved for at least 180 days. And that's the end of the ballgame.
And can I use the withdraw? Okay, if the company A has withdrawn the I-140, and can I go back to company A? Can I file the 485 with company A if the priority date is correct?
So let's say company A filed the I-140 and then subsequently withdrew it. You can go back to company A. You can use that same perm from the withdrawn I-140. I would tell you to refile the I-140. You use the old perm. You don't need to obtain a new perm. You refile the I-140. 99.9% of the time, you had that first one approved. That tells me you're going to get the second one approved. Then you file the 485. And you can do it concurrently. You don't need to wait on this refiling I-140 to be approved to go forward with the 485. As long as your priority date is current, you can do the I-140 and the 485 at the same time. No problems.
If I have an I-140 approval with company A and the priority date is correct, I'm working with company B right now. Can I file 485 without the help of company A 485 application?
Absolutely not. No.
Why not? You said priority date can be carried.
Yeah. So to be sponsored for the 485, you need an I-140 that supports the job from the company who's supporting the 485. And so let's say company A is the only one with the I-140. There's nothing that company B can do to support my 485. Why? Because company A is the only one with the I-140. So what can I do? I can either go to company B and say, company B, please do my perm for me so that you can get my I-140 so that I can file my 485. Or I can go to company A and I can say, company A, pretty please, will you sign my 485J? Yeah, I might not be employed with you. It doesn't matter. Can you sign my 485J? I would say 90% of the time the company will be willing to. They kind of understand the background issues. They'll sign the 485J. You might be working with company A. On paper, your green card is through company A. You file your green card, the 485 with the 485J from company A, with the I-140 from company A, and then after 6 months, you can have company B take over the entire process with their own 485J after 180 days, same or similar job opportunity. So that's another way that you could play it, if company A is unwilling.
I'll go to the question, very good question that comes up very often. Vijay Raghavan, can we file a lawsuit against the USCIS for not counting family members against the 140K annual limit? The answer is no, Vijay. As Rain has pointed out, that the administration can read the law in a way that is more suitable to them. But if the law is not clear, if the law says that do not count the family members, and the administration is counting the family members, we can sue them. That's for sure, we can do that. But if the law is not clear on it, then it's up to the administration to determine whether or not they should count the family members. They don't have to stick with the old rules. Oh, previously we didn't count we counted the family members, now we have to count. There is nothing like that. So it is up to the discretion of the administration that has been given there. Since the beginning, I think so this law was passed in 1992 or somewhere around that. even before I got the green card though. That's when the law has been passed and it's not been modified, but it's not clear. It doesn't say to count the family members. Let's take, for example, Vijay, in the H1B case, we do have 60,000 plus we have 65,000 plus we have 20,000. You know that is right. So in the 65,000 plus 20,000, are we counting the family members? Absolutely not. We don't count the family members, H4 members at all. Why are they doing on the green card? Well, the law is not clear. So we can't sue them. What our request would be that to administration is to look us in a favorable way. As Ren has pointed out that in EB2 cases, EB1 and other cases, the USCIS is promoting the STEM degrees. They say if you have a STEM degree, they should be looked into a much favorable way. That's what Ren has pointed out. Now, in the same way, if they just read it a little bit differently, well, can we force them to do it? No, we cannot force them to do it.
Yeah, it's a very good point.
Now, come to the question, why do you keep this bat in your home, in your office all the time, Ray?
To keep you away.
This is a kookaburra bat. I don't know why he keeps it. Keep me away. What do I do? I don't bowl. Anything else?
We'll take one more on the side. So, Jafar, I wouldn't say that you've got yourself into a sticky situation here, but you say that your current company B filed your 485 using company A's I-140. Your EAD and your AP have been approved. Can I use that, or will I have any issues? Just based on what you're telling me, I really don't have much optimism that your 485 is going to be approved.
Wait.
Yeah.
He filed with he has an I-140 with company A. Company B filed the 485 application.
I'm asking how, yeah.
How?
Yeah, and so if that's the case, you may see your 485 denied that you don't have an I-140 that properly supports it.
I have another problem.
You have scarier thoughts than I do on this, yeah?
Yeah, I think so that's a fraud.
Yeah.
Committed by company B and this guy too. Because when you file the 485 application, either you have an I-140 approval or you have to file a 485J supplement. Mm-hmm. So if they file the 485J supplement, who signed the 485J supplement?
Yeah.
It can't be company A. If the company A signed the 485J supplement, that's fine. If the company B filed it, that may be considered as fraud though.
And it may be an innocent misunderstanding of what the 485J is.
Yeah, I think so, you're right.
And so think on things, maybe contact an attorney to really dig down on that. I really hesitate to tell you to use your EAD and AP because it might hurt your non-immigrant status or prevent you from using your non-immigrant status, which can kind of snowball issues. And so speak with an attorney and dig down on that, Jafar.
Ravi has a question for you, Ryan. Can I have an I-140 approval with company A? And now I go to India. I stay there for 3 years. Can I come back on H1B with company B? My I-140 is not withdrawn within 180 days.
No problems at all.
When I come back, can I put the date with company B after 3 years I stay in India?
Absolutely.
Can I go back to company A and if the priority date is current, can I file the 485 with company A? I've been stayed 3 years. How about if it's 7 years?
70 years.
70 years I can stay.
You're an older guy at this point, but there's no length of time that you will spend outside the country that will cancel out your I-140 at all.
Anything else, Ryan, before?
No, nothing to add. Thanks, Rahul.
Thank you very much for tuning in, guys.
Thank you.